Welcome to Justice Lens, where we dive deep into real-life courtroom moments to uncover how justice unfolds, one case at a time. Today's story takes us inside two unique courtroom encounters, each featuring a pro se defendant, someone who chooses to represent themselves without an attorney. But while both stood alone before the law, their journeys took very different turns. In the first case, we meet Georgia driver Sidney Steele, who was cited by Lieutenant Jonathan Carey of the Clayton County Sheriff's Office for allegedly following too closely and making an improper lane change. Ms. Steele pleaded not guilty on May 16, 2024, and after more than a year of waiting, her day in court finally arrived, a Zoom bench trial in the State Court of Clayton County presided over by Judge Tammy Hayward on August 27, 2025. What followed was a calm, respectful, and well-structured exchange, a shining example of how confidence, clarity, and composure can make all the difference in a courtroom. But stay tuned, because after Sidney's trial, we'll witness a very different outcome when another self-represented defendant, Mr. McLeod, tries to challenge the court's very authority, and things take a turn he never saw coming.
Okay, you're charged with following too close on 2024 TK 06653. You're also charged with improper lane change on case 2024 TK 06652. Mr. Tipton, are you ready to go forward with trial?
Yes, Your Honor. State's going to call Lieutenant Jonathan Carey to the Zoom call.
All right. Lieutenant Carey, raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true? All right. You can put your hand down, sir. All right, Ms. Steele, you understand that you have the right to ask questions of any witnesses brought by the state. The state has the burden of proving the case against you beyond a reasonable doubt. You do not have to give any testimony or evidence against yourself. You have a Fifth Amendment right against self-incrimination, and the state needs to prove the case beyond a reasonable doubt. All right, do you understand?
Yes.
All right, Mr. Tipton, you may introduce your witness.
Yes, Your Honor. Lieutenant Carey, please state your name for the Zoom call.
Lieutenant Jonathan Carey.
All right. And Lieutenant Carey, how are you currently employed?
Currently the lieutenant for the Clayton County Sheriff's Office Black Hawk Traffic Unit.
And how long have you been with the Clayton County Sheriff's Office?
The Sheriff's Office, probably a little over 2 years.
Mm-hmm. And you have prior experience before that, correct?
Yes, I was with the Clayton County Police for about 4 or 5 years.
Okay. And during that time, both with the Sheriff's Office and the Police Department, have you been post-certified?
Yes.
Okay. And being post-certified, are you authorized to investigate crimes, issue citations, and make arrests based on your investigations?
Yes, I am.
Okay, then. So I want to bring your attention to March 20th of 2024. Were you working for the Clayton County Sheriff's Department at that time?
Yes.
And were you on duty that day?
Yes, I was.
Okay. Did you at any point in time have occasion to make contact or initiate a traffic stop with a white Chevrolet Trax that was driven by Miss Sidney Steele?
Yes.
Okay. Can you tell me about what drove you to or what caused you to initiate contact with Miss Steele?
Yes. So during my role during the day, I look for erratic lane changes, reckless drivers, speeders. So while traveling northbound on Bear Boulevard, passing over 88, I was monitoring traffic in my rearview mirror. I observed a white SUV changing several lanes, not giving the public enough notice that she was changing lanes, nor was she using a nor was the vehicle using a turn signal. I observed the vehicle getting closer to me as she was changing lanes. She was also following another vehicle too close. Once she changed from lanes 2 back to lane 1 several times, she passed me. I'm sorry, from lane 3 to lane 2, she passed me in lane 3. And that's when I conducted a traffic stop on that vehicle and spoke with the driver. While speaking with the driver, she advised that she was in a hurry to get to Atlanta because she had a hair appointment.
Okay. You stated she didn't use any turn signals. Is that correct?
Correct.
Okay. And what was the basis of the following too close?
She was following another vehicle too close as she was changing lanes.
Based on your knowledge, your training, and your experience, as well as what you observed, was that a safe maneuver for her to make?
No, it was not.
Would a reasonably prudent driver um, would a reasonably prudent driver have followed that closely?
No. And if that vehicle in front of her would have slammed on the brakes, she would have been at fault, and that definitely probably would have caused an accident.
Okay. And with the improper lane change, was there anything improper? Tell me about what was improper about that lane change besides just the signal.
So when you change lanes, you have to give the public enough notice that you're about to change lanes, which she failed to do
Okay.
several times, not just one time.
Okay. So about how many lane changes did you observe?
I believe I observed 3. So she went from the number 3 lane to the number 2 lane, then back to the number 3 lane.
Okay. This occur in Clayton County?
Yes, it did.
Okay. I have no further questions at this time.
All right, Ms. Steele, did you have any questions of Lieutenant Carey?
Yes.
Go ahead, ma'am.
So you said that you were observing me in your rearview mirror when I
Correct.
did all of these okay. So if you're observing me in my rearview mirror, how are you able to see how close I'm driving behind another car? If you're looking in your rearview mirror, you would see the car that's in front of me. You wouldn't be able to see my car.
I can see your car and the car in front of you.
Got you. So how are you able to determine how close my tires were to the trunk of the car in front of me?
I can't determine how close your tires are, but I can determine how close your bumper is to their rear bumper
And how are you able to do that?
by looking at it.
And what did you see? How close was I? If you had to guesstimate.
You're less than a car length behind them.
Less than a car length?
Correct.
And this was another car and this was not your car?
Correct.
Okay. I don't have any more questions for you.
After Assistant
Alright.
Solicitor General Tipton finished questioning Lieutenant Carey, Ms. Steele was given the chance to cross-examine him, to challenge his version of events, and ask her own questions. During this exchange, Lieutenant Carey claimed he saw how closely Miss Steele was following another vehicle, using only his rear-view mirror, and estimated that she was less than a full car length behind it. Now, under Georgia Code Section 40-6-49, drivers must not follow another vehicle more closely than is reasonable and prudent, considering the speed, flow of traffic, and road conditions. This law doesn't set an exact distance. Instead, it relies on what a reasonable driver would consider safe. In the 2009 case of Proctor v. State, the Georgia Court of Appeals ruled that an officer had legal grounds to stop a driver who was about one car length behind another vehicle on the highway. The reasoning was simple. At that distance and speed, the driver likely couldn't avoid a crash if the car ahead braked suddenly. By that same logic, Lieutenant Carey's testimony that Miss Steele was less than one car length behind another car could, at least on paper, provide enough reason to justify a citation for following too closely. But as we'll soon see, the full picture of this traffic stop is more complicated than it first appears.
Anything else, Mr. Tipton?
Briefly, Your Honor. Lieutenant Carey, was your view of the car immediately in front obstructed?
No.
Was your view of Miss Steele's vehicle obstructed?
No.
Which lane were you in, sir?
I was in the number 2 lane.
Okay. And which lane did you observe the vehicle in when it was following too close?
Number 3.
Okay. Would you
So-
say that?
No, well, when she was following too close, she was in the number 2 lane as well.
Okay.
She went from number 3 lane to the number 2 lane, followed the car too close, and then switched back to the number 3 lane.
Okay. Were there multiple cars that she followed too close to, or just the one?
Just the one.
Okay. Okay. And so you had an unobstructed view of her front bumper and the rear bumper of the car immediately in front of her, correct?
Correct, by using my side mirror at the time.
Okay, awesome. Thank you. No further questions.
All right,
I do have just one more question.
go ahead.
What was the kind of car that I was driving behind?
I'm not sure.
Okay. Do you remember the color?
No, I don't.
Okay.
After Miss Steele finishes her cross-examination, Assistant Solicitor General Tipton steps in once more, requesting a redirect to clarify Lieutenant Carey's earlier statements. But during this brief exchange, Lieutenant Carey's account begins to shift. Initially, he had testified that he observed Miss Steele following another car too closely through his rear view mirror. Now, however, he claims that he actually saw both her vehicle and the one ahead through his side view mirror instead. Sensing the inconsistency, Miss Steele presses further, asking a simple but revealing question. "Do you even remember what kind of car I was supposedly following?" Lieutenant Carey admits that he's not sure. He can't recall the type or even the color of the other vehicle. This line of questioning by Miss Steele wasn't accidental. It was a smart, deliberate effort to expose weaknesses in the officer's memory and cast doubt on the reliability of his entire account. By showing that his testimony changed mid-hearing and that he couldn't identify the very vehicle central to his claim, Miss Steele effectively challenged both his credibility and the strength of the state's evidence against her.
All right. Did the state have any additional witnesses to present?
No, Your Honor. State's going to rest this time.
All right, Ms. Steele, did you wish to present evidence and testimony?
Yes.
All right, you understand that you're not required to present any evidence or testimony?
Yes.
All right, you're waiving your right to remain silent in order to offer evidence and testimony?
Yes, ma'am.
All right, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes.
All right, you can put your hand down. Go ahead, tell me what you need me to know.
Okay, so the day this happened, I stopped at the gas station. At the time, I was 6 months pregnant. I stopped at the gas station, grabbed some water. I get out of the gas station, I turn right. As soon as I turn right, I turn into a light. I pulled behind the police officer. No other car was in front of me other than the police officer. When the light changed, it's like he wasn't moving. So I put my signal on to get in the lane to the right of me. I got in the lane to the right of me. He then got in the lane behind me. And I looked in my rearview mirror and I'm like, he is driving so close to me. Like, he was so close. I could not see his tires. This is why I asked these questions, because in driver's training, they teach you have to at least be able to see the car's tires behind you. So that's how I was able to determine that he was driving too close to me. It was not a car length behind me. So then I'm like, okay. So I put my signal on, get back in the left lane. He gets back in the left lane. So I'm like, what is happening right now? Like, I was so confused as to what's happening. I'm like, am I in his way? What's going on? So then I did get back into the right lane. And when I went to get into the right lane, that's when he turned this light on and pulled me over. And I was confused as to, one, why he chose to do that. Because like I said, I was just confused. And he asked me, I asked him, why did you pull me over? And he said, are you in a hurry or something like that? And I was like, well, I'm trying to get to my hair appointment because I was going to get my hair done for my baby shower. And he's like, okay, and then asked for my information. And when he came back and told me, one, driving too close, I'm like, how was I driving too close when I pulled up behind you at a red light? So I literally was not driving. You weren't driving. The light was red. And then when the light changed colors, you didn't really take off. So I'm like, okay, let me get out of this man's way because I have somewhere I have to go. And clearly he does not. So that's when I got over. And also, I have a 2024 Chevy Trax. My car, you literally cannot switch lanes without putting your signal on because it will jerk you back into your lane. So for one, I don't change lanes, especially while I was 6 months pregnant, without giving anybody proper notice, because I wouldn't want to put myself or my son in danger. And then that's why I also asked, what was the car? Because, there literally was not another car in front of me other than him. And then when I got over, for him to see all of these different lane changes, he was right behind me. And I did switch lanes that many times because he was driving so close up on my bumper to where he was correct. If I would have put on my brakes, he would have hit me in the back of my car.
Okay. Any questions, Mr. Tipton?
No, Your Honor.
All right. Anything else, Ms. Steele?
No, ma'am. No, Your Honor.
Okay. Argument?
State will submit on the facts, Your Honor.
All right. Ms. Steele, I found you not guilty of the offenses before the court. Each of you are given testimony in this case. Each person has submitted sworn testimony without additional evidence. Neither testimony has greater weight than the other. Therefore, the court is not able to determine beyond a reasonable doubt that you committed an offense in this case and finds you not guilty on both offenses.
Thank you.
After Miss Steele gives her version of events, one that differs sharply from Lieutenant Carey's account, Judge Tammy Hayward delivers her verdict: not guilty on both charges. Miss Steele's calm, logical defense and careful questioning successfully created reasonable doubt, and that was enough to clear her name. But not every pro se defendant fares as well. Our next case takes us from Georgia to Michigan, where another self-represented defendant's courtroom experience unfolded in a completely different way. On September 3, 2023, a Michigan man named Trevor McLeod was charged with 2 serious offenses: operating a watercraft while intoxicated, a misdemeanor, and resisting or obstructing conservation officers, a felony. He was arraigned just 2 days later and released on bond. Following a preliminary hearing, his case was transferred from District Court to the 53rd Circuit Court in Sheboygan County under Judge Aaron Gauthier. The court scheduled an arraignment and pre-trial hearing for December 19, 2023, and this time, Mr. McLeod made a bold decision. He would represent himself.
Before I accept that waiver, to do a couple things. One, advise you of the maximum penalties that you could face for the charges that you're in my court for. Resisting, obstructing conservation officers is a high court misdemeanor punishable by up to 2 years in prison and or $1,000 fine. There's a habitual offender second notice that's been filed by the could make that a felony punishable by up to 3 years and or $1,000 fine. And marine safety operating while intoxicated is a misdemeanor punishable by up to 93 days and or $100 to $500 fine. Do you understand the maximum penalty for the charges against you?
Well, I don't even really understand why I'm here, honestly.
Well, okay. Well, that's fine. Do you understand the maximum penalty that I just explained to you?
No.
Hold on. I can't let you represent yourself until I establish a couple things.
Well, I need to establish a couple things too, honestly.
Hold on. Well, I can't let you represent yourself until I establish a couple things, or I'm going to be in trouble.
Okay.
Do you understand that the maximum penalty that you could face for the charges that you're here for is up to 3 years in prison and or $1,000 fine?
I don't understand the nature and cause of the action against me. So
what is it that you don't understand? Do you not understand how long 3 years is, or how much the fine is that I've articulated? Can you tell me what it is you don't understand?
The nature and cause of the action against me because we don't establish jurisdiction.
That's not what I'm asking you right now. Well, I'll let you place whatever objections you want on the record, Mr. McLeod. I promise you that. Okay. Can we just go one step at a time? So do you understand the maximum penalty that you could face if you're convicted as charged? 3 years in prison or $1,000 fine?
Well, I have another question because the statutory jurisdiction doesn't exist under the Constitution. So in order for me to defend myself, could you please tell me where the published rules of conduct are for criminal statutory jurisdiction? Or where I can find the nature and cause of this jurisdiction or how this information exists.
No, I don't even understand what you're asking.
So you're saying this is a statutory jurisdiction under what? The statutes of Michigan, correct?
Mr. McLeod, I've told you what my jurisdiction is.
General
The
jurisdiction.
people of the state of Michigan voted to convene a constitutional convention in 1961.
Sure.
There was a constitutional convention in 1961 and 1962. They proposed a state constitution. The voters of the state of Michigan ratified that in 1963. Article 6 establishes the judicial power. And the circuit court is a court under that judicial power of Article 6 of the state constitution. And so you're here in my court. I have subject matter jurisdiction over those crimes. I have personal jurisdiction over you because you've been alleged to have committed them in our county. That's my jurisdiction. So Mr. McLeod, you want to represent yourself? Do you understand the maximum penalty that you could face of 3 years in prison and or $1,000 fine?
Mr. McLeod begins by challenging what he calls the jurisdiction of the court. Judge Aaron Gauthier calmly responds, explaining that the court has both subject matter and personal jurisdiction under the Michigan Constitution and state law. Now, when a defendant challenges a court's jurisdiction, they're essentially claiming that the court doesn't have the legal power to hear their case or issue a ruling against them. In reality, a court can only act if it's been granted authority by the Constitution or by statute. Subject matter jurisdiction means the court's authority to hear the type of case in question. In this instance, that's a criminal prosecution under Michigan law. Circuit courts in Michigan are courts of general jurisdiction, which means they can handle nearly all civil and criminal cases that arise under state law, unless a specific law assigns a case elsewhere or to the federal system. Personal jurisdiction, on the other hand, is about the court's authority over the person being charged. Here, the 53rd Circuit Court clearly has personal jurisdiction because the alleged crime took place within its county limits, and Mr. McLeod was lawfully summoned before the court. So, despite his confident tone, Mr. McLeod's claim that the court had no jurisdiction wasn't supported by any legitimate legal basis.
One second.
I can see why his attorney withdrew. Oh, shit.
Hang on, someone in the prosecutor's office is not muted. I'm going to remove you from the meeting at this time.
Oh,
Prosecutor's office is generally allowed to attend to observe. They've participated. I'm removing them from the hearing. Mr. McLeod, do you understand the maximum penalty that you could face?
1 second. Okay, so when enforcement of mere statutes, judges of all courts do not act judicially and are thus are not protected and qualified by limited immunity. That's Owen versus the city. I just want to state a few things for the record since you're claiming this is a jurisdiction under statutory law.
Hang on. Mr. McLeod, can we back it? Look at me for a second. Can we talk here?
I challenge subject matter jurisdiction. Nothing can go forward until that's addressed. You're saying
I did address it and I denied your objection. I have subject matter
doesn't
jurisdiction.
exist under the Constitution.
Your objection is noted. So, Mr. McLeod, do you understand? Let me explain to you.
Sure.
Sometimes, as I said, people might want to represent themselves, but let's say they have limited intellectual capacity and they don't understand what's going on. I have to establish that they know what's going on before I can allow them to represent themselves. I'm required to establish, do you comprehend, do you know the maximum penalty that you could face if you're convicted as a result of this charge? 3 years in prison or $1,000 fine. Do you understand that, Mr. McLeod?
So I'd like to state for the record that
Mr. McLeod, stop.
the court can be.
Stop, Mr. McLeod. If you don't understand it, I'm going to revoke your right to represent yourself and have an attorney represent you because I can't establish that you know what you're doing. So do you know the maximum penalty that you would face?
I've challenged this court's jurisdiction. You haven't established it yet. You said you've got a statutory jurisdiction, which doesn't exist under the Constitution. I'm trying to figure out where I stand with this. So I can't answer any of your questions until you answer some of mine.
That's not how it works. Are you refusing to answer my question?
No, I'm
Then answer it. Do you understand the maximum penalty that you face for this charge?
So judges who become involved in enforcement of
Mr.
your
McLeod,
statutes.
I have other matters,
Clerk,
Mr.
some
McLeod.
involved agency. What's that?
You know, I understand you want to object to things and you're going to be allowed to object to things. Okay.
Sure.
But we have to do things one step at a time. And I do have other cases today. I'm not going to entertain this for like a whole hour. I've got other cases going on. If you want to dig in your heels and just make this real complicated or real difficult, we could do that. And I can hold you in contempt and you'll go back to a jail cell for a while.
Your
and then
Honor,
we'll deal with
I
it.
don't wish to be held in contempt. I just wish to exercise my Sixth Amendment right.
That's fine.
And
So before I can let you under,
I can
before I
cite
can,
laws, I can cite laws that will show you that the exercise of a right can be converted into a crime. I'm trying to understand the nature and cause of the action against me. You're not clarifying it enough to where I can comprehend it, as you say.
you comprehend the maximum penalty that you would face.
I'm not answering any of those questions until you establish that this is a court of the Constitution, has jurisdiction under these jurisdictions.
I established it. I told you. You might think I'm wrong and you can appeal
There's
it.
no
to the
such
Michigan
thing as
Court
a
of Appeals.
statutory jurisdiction.
Mr. McLeod, let me make this simple for you. Do you ever watch, let me make this simple for you.
Sure.
I'm going to ask you this question one more time. One more time.
Okay.
Two things are going to happen. You are either going to answer my question or I'm going to hold you summarily in contempt. And the court officer will bring you to a jail cell and we'll talk about it tomorrow. You understand that?
So.
Mr.
in
McLeod,
contempt for what?
Mr. McLeod, two things are going to happen. You're going to answer my question or you're going to jail for summary contempt for not complying with the court's request. Do you, Mr. McLeod, understand that the maximum penalty for the charge against you is 3 years in prison and or $1,000 fine?
I don't understand the charges.
Mr. McLeod is in contempt of court taken into custody.
Really? God's sake.
After Mr. McLeod repeatedly refused to answer Judge Gautier's questions, the judge found him in contempt of court and sentenced him to 1 day in jail. As the case progressed, Mr. McLeod continued representing himself, but his behavior grew increasingly erratic and disruptive. By July 2024, Judge Gautier revoked both his bond and his right to self-representation after Mr. McLeod refused to accept court mail and failed to appear for a scheduled hearing. The case finally came to an end in September 2024 when he pleaded guilty to 1 felony count of resisting and obstructing a conservation officer and 1 misdemeanor count of operating a vessel while impaired. He was sentenced to 69 days in jail, received full credit for time served, was fined, and had his boating privileges suspended for 12 months. Now, while both defendants we've seen today chose to represent themselves, the difference in their approach and their outcomes could not be more striking. Miss Steele came prepared, respectful, and grounded in the facts. She understood the charges, followed courtroom procedures, and used logical cross-examination to reveal inconsistencies in the officer's testimony. Her calm, focused demeanor helped her earn credibility and ultimately an acquittal. Mr. McLeod, on the other hand, faced far more serious charges, but treated the courtroom as a stage for defiance. His refusal to answer questions, constant disruptions, and obsession with jurisdictional arguments showed a lack of understanding of how the legal process works. In the end, his behavior forced the judge to take away his right to represent himself. These two contrasting cases illustrate a powerful truth. The right to self-representation is constitutionally protected, but using it effectively demands far more than confidence. It requires preparation, discipline, and respect for the rules that govern the courtroom. Ms. Steele's case shows that a well-prepared, respectful defendant can indeed prevail, especially in lower-level cases like traffic offenses. But Mr. McLeod's experience reminds us how quickly things can spiral out of control when those qualities are missing. If there's a courtroom moment or case you'd like us to analyze next, let us know in the comments below. Thanks for watching, and don't forget to subscribe, like, and share so together we can help build a more informed and justice-aware society.